Hi everybody, how are you? Hope you have revised the content that we have discussed in the previous class. In the previous class, we have completed section number 73 and 76 of acceptance of deposits. Now, before starting today's class, let us revise the content that we have discussed in the previous class in just 5 minutes. Okay, after revising, we will move into today's class. First of all, from whom deposits can be accepted? Okay, deposits can be accepted either from members or from public. Okay, from members, which types of companies can accept deposits, and from public, which types of companies can accept deposits? Basically, there is a classification of eligible and non-eligible companies. In order to accept deposits from public, you must be a eligible company. Okay, and from members, both eligible and non-eligible members, non-eligible companies can accept deposits. And section 73 governs acceptance of deposits from members, and section 76 governs acceptance of deposits from public. Okay, now who are eligible companies? There are basically three conditions. In order to be a eligible company, first of all, it must be a public company, and it must have net worth of at least 100 crore or turnover of at least 500 crore. Okay, either of these conditions, and it should obtain general meeting, ordinary resolution or special resolution from its members. Okay, ordinary resolution or special resolution will be determined as per section 180 subsection 1 clause C. Okay, we have seen that. After that, now if you want to accept deposits from members, then you can be either eligible or non-eligible company, and you need to satisfy certain 5 conditions, or you need to follow certain 5 steps. What are those steps? First one, you need to issue circular or advertisement in form DPT1, and you need to register this circular with the ROC at least 30 days prior to its circulation. Okay, after that, what should you do? Yeah, DRR. You need to maintain deposit repayment reserve and at least 20% of the amount of deposits that are going to be matured in the coming year has to be deposited into this DRR account, and that account must be maintained in a separate scheduled bank. Hope this is clear. After that, there should not be any subsisting default, and at least 5 years should have been elapsed from the last date of making good the last default. Okay, even that point we have discussed. After that, the deposits that you are accepting from members can be either secured or unsecured. Okay, if at all they are secured, then proper charge must be created. And for accepting deposits from members, you need general meeting, ordinary resolution. Hope this is clear. Coming to acceptance of deposits from public, in this case you will be requiring general meeting, ordinary resolution or special resolution, and all the points that we have discussed for members will be applicable even for deposits from public. And the important thing here is that the deposits that you accept from the public must be secured one. Okay, you cannot accept unsecured deposits from the public, and you should also obtain credit rating. Okay, this credit rating has to be obtained for each year. Hope this is clear. Till this point we have discussed in the last class. Now we will see some more points. See, basically if you see how much of deposits can be accepted. Okay, till now we have seen that which types of companies can accept deposits, from whom deposits can be accepted, and what is the procedure to accept the deposits. Now the question arises is whether company can raise how much of deposits it wants, or there is any limit on the maximum amount of deposit that a company can raise. Okay, there is a limit. Okay, company cannot raise unlimited deposits. There is certain limit prescribed by the act. Company has to raise deposits only within that limits. Okay, let us see those limits. maximum amount of deposits that can be raised. What is the maximum amount of deposits that can be raised? That can be raised. Here we have two types of companies. Okay, there are eligible companies and there are non-eligible companies. There is separate limits prescribed by for these eligible companies and for non-eligible companies. Okay, so first of all we'll classify it into eligible and non-eligible. Eligible companies and in case of non-eligible companies. First of all, let us see for eligible companies. In case of eligible companies, there is a further classification. Okay, once the company is an eligible company to raise deposits from the public, then you have to check whether the company is a government company. Okay, government company or non-government company. If it is a government company, then the limit is maximum 35% of paid up share capital plus free reserves plus securities premium. Okay, in case of eligible company and that eligible company is a government company, then maximum amount of deposits that can be raised by this eligible government company is 35% of its share capital, free reserves and securities premium. Okay, let's say the paid up share capital of this government company is some 700 crore. Okay, and free reserves is some 200 crore and security premium is 100 crore. Now what will be the maximum amount of deposits that can be raised by this government company? It will be 1000 crore multiplied by 35%, that would be 350 crore. Okay, this should be the maximum amount of deposits that the eligible government company can raise. Hope this is clear. Next, in case the company is a non-government company, okay, in that case there is a separate limit for members there is separate limit for acceptance of deposits from members and from public. Let us see. First of all, deposits from members, deposits from public. Here it is from members 10%. 10% of paid up share capital plus free reserves plus securities premium. Okay, and here from public maximum, you can write word maximum. Okay, here also max 25% of paid up share capital plus free reserves plus securities premium. Okay, see, let us see this. You are determining the maximum amount of deposits that a company can raise. Now there is a separate limit for eligible and non-eligible companies. Now first of all we are seeing for eligible companies. Okay, now in case of eligible companies, there is different limit for eligible government companies, there is different limit for eligible non-government companies. In case of eligible government companies, the maximum amount of deposits that can be raised are 35% of paid up share capital, free reserves plus securities premium. In case of non-government eligible company, there is separate limits prescribed for both members and public. for members it is 10% of paid up share capital, free reserve, securities premium. From public it is 25% of paid up share capital, free reserve, securities premium. Now if you observe here, in the first case, in this case, government company case, they have set 35%. Okay, and there is no separate limit for from members, from public. That means this 35% entirely can be accepted from public, or entirely can be accepted from members, or some portion can be accepted from members, some portion can be accepted from public. Okay, there is no bifurcation in case of government companies. Okay, for this 35%. Whereas in case of non-government company, here also if you see, if you add up this 10% and 25%, it will be 35% only. Okay, but in this 35% again they have given the bifurcation. Okay, maximum 10% from members, maximum 25% from public. Hope this is clear. Okay, next, moving to non-eligible companies. And if you observe, this eligible companies can only be public companies. Okay, we have seen the definition of eligible companies. Okay, eligible company can means only a public company satisfying the criteria. A private company can never be a eligible company. Okay, now coming to non-eligible companies. In case of non-eligible companies, there can be both public companies and private companies. Okay, if it is a public company, okay, the company is a public company, but it is a non-eligible company because it is not satisfying any of the three conditions. Okay, then it becomes non-eligible companies. In that case, the maximum amount of deposits that can be accepted by a non-eligible public company is 35% of paid up share capital plus free reserves plus securities premium, and this can be accepted only from members. Okay, non-eligible company cannot accept from public. Okay, you should remember that this entire 35% should be only from members. Okay, next, private companies. See, in case of private companies, they can accept up to 100% of paid up share capital plus free reserves plus securities premium. Okay, for private companies it is 100%. If you see in your institute's study material, they have not mentioned this point. Okay, they have not mentioned this point of private limited company. Okay, I am telling you extra. Okay, you need not, if you don't want to remember it, you need not remember it. Okay, but for private limited companies it is 100%. Okay, and there is another category. That another category is startup companies. Okay, basically startup companies means those companies for which government has given recognition of startup. Okay, this will be valid for 5 years. Those startup companies can accept without any limit. Without any limit. Okay, hope this is clear. Actually, these 2 points are not there in our syllabus. Okay, but this chart will be incomplete without telling these 2 points, and I don't know why institute has not kept these 2 in our syllabus. Okay, so these are the various limits. If you want, you can make a note. First of all, you can write this. You can pause the video and make a note. I'm scrolling it. Next to this one. Hope you are done. If you are done, we'll move into our book. If you are not done yet, you can pause the video and you can make a note. Okay. Now, the same points we will see here. See. Terms and conditions of acceptance of deposits by companies. What are these terms and conditions? On and from commencement of these rules, no company referred to in subsection 2 of section 73, that means non-eligible companies, and no eligible company, okay, either eligible company or non-eligible company, both companies shall accept or renew any deposit, whether secured or unsecured, which is repayable on demand or upon receiving a notice within a period of just a second, we'll discuss this point later. I have not discussed this point yet. I'm keeping this point as pending. Okay, here we kept one point as pending. In above page also we have kept one of the point pending. Where is that? Yeah, this point. Even this one we kept pending. We'll discuss them. Yeah, this one from here. See, no company referred to in subsection 2 of section 73 shall accept or renew from its members if the amount of such deposits together with the amount of other deposits outstanding as on the date of acceptance or renewal of such deposits exceeds 35% of the aggregate of paid up share capital, free reserves and securities premium account of the company. Okay, first of all, section 73 subsection 2 means non-eligible companies, okay, which are eligible to accept deposits only from members. Okay, these companies can accept deposits of maximum 35%. Okay, this point which we have discussed here, this one, this point. Okay, actually even this point has to be specified in the study material, but the institute has not given it, so we are not discussing them, but for your knowledge I have given these two also in the chart. Okay, then next what it says. Next, coming to eligible companies. No eligible company shall accept or renew any deposit from its members if the amount of such deposit together with the amount of deposit outstanding as on the date of acceptance or renewal of such deposits from members exceeds 10% of the aggregate of the paid up share capital, free reserve, securities premium. See, first of all, this is eligible company. Okay, we are discussing about eligible company, and clause A discusses about acceptance deposit from members. Okay, members, eligible company, then the percentage is 10%. Hope this is clear. Next, moving to eligible company, public. Any other deposit if the amount of such deposit together with the amount of such other deposit other than the deposit referred to in clause A. Okay, other than the deposit referred to in clause A means in clause A which deposit is referred? Deposit from members is referred. Other than deposit from members means deposit from public. Okay, indirectly clause B is speaking about deposits from public. Okay, what is the limit for deposits from public? Clause A, outstanding on the date of acceptance or renewal exceeds 25% of aggregate of paid up share capital, free reserves and securities premium account of the company. Hope this is clear. Eligible company members 10%, public 25%. Okay, the point that we have discussed. Next, coming to government companies. In case of eligible company, government company, see, no government company eligible to accept deposits under 76 shall accept or renew any deposit if the amount of such deposit together with the amount of other deposits outstanding as on the date of acceptance or renewal exceeds 35% of the aggregate of the paid up share capital, free reserves and securities premium. Okay, in case of government eligible company it is 35%. Okay, the entire chart that we have discussed has been covered here. Okay, subsection 3, subsection 4, subsection 5, these 3 points we have discussed in the form of the chart. Hope this is clear. Next, no company referred to in subsection 2 of section 73 or any eligible company shall invite or accept or renew any deposit in any form carrying a rate of interest or pay brokerage thereon at a rate exceeding maximum rate of interest or brokerage prescribed by Reserve Bank of India. Okay, the amount of the rate of interest that the companies will give on the deposits should not exceed the amount of the rate of interest prescribed by Reserve Bank of India. Okay, Reserve Bank of India will specify a certain rate of interest. Okay, and the rate of interest that the company is paying on the deposits should not exceed that rate of interest. Hope this is clear. Okay, however, you need not know that rate of interest. Next, the company shall not reserve itself either directly or indirectly a right to alter to the prejudice or disadvantage of depositors any of the terms of conditions of the deposit, deposit trust deed and deposit insurance contract after the circular or circular in the form of advertisement is issued and deposits are accepted. See, basically before company issues deposits, it will circulate a circular or the advertisement. In that circular or in the advertisement, there will be the terms and conditions that will be applicable to the deposits. Okay, and there will be various other aspects related to deposits. Now, after circulating the advertisement and after raising the deposits, the terms and conditions that were specified in that circular should not be altered by the company. Hope this is clear. Next, those are some of the points. Next, we'll discuss tenure of the deposits. Okay, what should be the maximum tenure of the deposits? Let us see. Tenure means repayment period. Okay, maturity period you can also say it as. See, tenure of deposits. The tenure of deposits not less than 6 months and not more than 36 months. 36 months. See, minimum tenure of deposits should be 6 months. Okay, a company cannot issue deposits whose tenure is less than 6 months. Okay, that is the downside tenure. Upside tenure, maximum tenure should be 36 months. Okay, a company cannot issue deposits with a tenure of more than 36 months. Hope this is clear. Okay, minimum tenure is 6 months, maximum tenure is 36 months. Okay, the tenure of sorry, the tenure of deposits that the company is issuing must lie between 6 months to 36 months. Hope this is clear. Okay, this is the general rule, but there is an exception to it. What is the exception? Exception to this first part. Okay, for this downside period, okay, for the minimum period there is an exception. What is that exception? See, deposits with a tenure of 3 months to 6 months can be issued provided they are max 10% of paid up share capital plus free reserves plus securities premium. Okay, see, first of all, the tenure of the deposits must be between 6 months to 3 years, and there is an exception. In that exception, company can also raise deposits with tenure of 3 months to 6 months. Okay, below 3 months it cannot rise. Okay, never company can give deposits for tenure below 3 months, but for tenure from 3 months to 6 months it can give, subject to the condition that these types of deposits, okay, with tenure of 3 months to 6 months or maximum of up to 10% of the paid up share capital, securities premium and free reserves. Okay, up to 10% of paid up share capital, securities premium and free reserves. Okay, that much amount of deposits can be given with a tenure of 3 months to 6 months. Hope this is clear. Okay, this is related to tenure of deposits. You can make a note of this. Tenure of deposits. Here you can write minimum maximum. Actually, I have had a tiffin of dosha, so I'm requiring more and more water today. When you eat dosha, you'll feel like sleepy. Okay, and you'll also require to consume more water that day. So I had dosha today. Okay, hope you are done. If you are not done, you can pause the video and you can make a note. Okay, yes, this point, pending point, this one, let us see it now. See, no company referred to in subsection 2 of section 73, that means non-eligible company. Okay, whenever you find section 73 subsection 2 means non-eligible company, you should remember non-eligible company. And no eligible company shall accept or renew any deposit, whether secured or unsecured, which is repayable on demand or upon receiving a notice within a period of less than 6 months or more than 36 months. Okay, this is the minimum tenure, this is the maximum tenure of deposits. from the date of acceptance or renewal of such deposits. Okay, provided that a company may, for the purpose of meeting any of its short-term requirements of funds, accept or renew such deposits for repayment earlier than 6 months from the date of acceptance or renewal, as the case may be, subject to the condition. What are these conditions? Such deposit shall not exceed 10% of the aggregate of paid up share capital, free reserves and securities premium. Okay, if you are accepting deposits for a period less than 6 months, then that total amount of deposits with tenure of less than 6 months should not be more than 10% of the paid up share capital, free reserves, securities premium. Okay, and such deposits are repayable not earlier than 3 months. Okay, you must repay that deposits not earlier than 3 months. That means the minimum tenure of the deposits must be at least 3 months. Okay, you cannot give the tenure lesser than 3 months. Hope this is clear. From the date of such deposits or renewal thereof. Hope this is clear. Okay, here general rule is 6 months to 36 months. In the exception, it is 3 months to 6 months, subject to maximum of 10% of paid up share capital, free reserve, securities premium. Okay, that's it. And we have a small point: where depositors so desire, deposits may be accepted in joint names not exceeding 3, with or without any of the clauses, namely jointly, either or severely, first name or survivor, anyone or survivor. Okay, basically in case of equity shares, there can be joint shareholders. Okay, for the equity shares. Even for debentures there can be joint debenture holders. In the same way, for deposits also there can be joint deposit holders. Okay, maximum there can be 3 joint deposit holders. Okay, that means, let's say company accepted a certain deposit of some 10,000 rupees. Okay, now this deposit of 10,000 can be jointly in the name of maximum 3 persons: Mr. A, Mr. B, Mr. B. Okay, hope this is clear. Okay, next, those are some terms and conditions related to acceptance of deposits, which is discussed by rule number 3. Rule number 3. Next to rule: creation of security. Okay, we have already discussed that deposits which are raised from members can be either secured or unsecured, but deposit raised from public must be secured only. Okay, related to that creation of security, rule number 6, let us see. Every company referred to in subsection 2 of section 73, that means non-eligible company, raising deposits from members, and every eligible company, okay, raising deposits from public or members, inviting secured deposits, shall provide for security by way of charge on its asset for the due repayment of the deposits and the interest thereon. Okay, the charge should be created for principal plus interest. Okay, yesterday we have discussed, company has raised a deposit of 100 crores for a tenure of 3 years with an interest rate of 10%. There the security, okay, the charge has to be created for 130 crores. Okay, 100 crores of principal plus 30 crores of interest. Hope this is clear. For an amount which shall not be less than the amount remaining unsecured by the deposit insurance. Basically this deposit insurance is not relevant now. Okay, I have discussed with you yesterday. Okay, that clause D, which was speaking about deposit insurance, was taken off, was striken off. Okay, under section 73 clause 2, under section 73 subsection 2, we have clause D, which has been striken off. Okay, which was related to deposit insurance. Next, the security not being in the nature of pledge of deposits as specified in sub rule 1 shall be created in favor of trustee for the depositors. See, basically on behalf of depositors there will be a trustee appointed. Okay, if you see in case of debentures, even for debentures also debenture trustee will be appointed. In the same case, even for deposits also deposit trustee will be appointed. Okay, generally there are some names of trustees specified. Okay, around 300 plus names of trustees have been given. From those trustees, any of the trustee can be selected by the company. Okay, basically all these trustees are like SBI and various banks and insurance companies have been listed. Okay, in that list of trustees, from those trustees we can select any of the trustee as the deposit trustee for your company. Okay, the depositors on specific movable property of the company or specific immovable property of the company. Okay, the charge can be created either on movable or on immovable. Okay, hope this is clear. But on intangible assets it cannot be created. Okay, company cannot give security of its intangible assets. Okay, those assets must be tangible assets. Hope this is clear. Next, just a second. Yes, appointment of trustee. As we have discussed, there will be a trustee appointed for these deposits. Rule 7 deals with appointment of trustees. No eligible company shall issue a circular or advertisement inviting secure deposit unless the company has appointed one or more trustees for depositors for creating security for the deposits. The trustees shall not be related to the directors and shall not have pecuniary interest on the company. See, first of all, we have discussed that in order to raise deposits, company has to issue the circular now. Okay, company has to issue circular. Now before issuing circular only, company needs to appoint the trustee. Okay, only after appointing the trustee company can issue the circular. Okay, in fact in this circular company should specify name of the person who has been appointed as a trustee. Hope this is clear. And after the deposits have been raised, okay, once the trustee will be appointed, then circular will be issued. After circular, deposits will be raised. Okay, then there will be deposit holders in the company. Okay, now after raising deposits in the deposit holder meeting of the company, this appointment of trustee will be ratified. Okay, because trustee is appointed on behalf of deposit holders only. Okay, now if trustee is acting on behalf of deposit holders means, first of all deposit holders has to approve the appointment of trustee now. Okay, thereby since trustee was appointed long back by the company, before raising deposits only the company has appointed the trustee. Thereby after raising deposits in the deposit holder meeting, okay, they will first of all ratify the appointment of trustee. Hope this is clear. Next, the company shall execute a deposit trust deed in form DPT2 at least 7 days before issuing the circular in the form of advertisement. Okay, the trust deed will be in the format as specified on DPT2 and it must be executed at least 7 days before. Okay, here I have told you that before issuing circular only trustee must be appointed na. Okay, here the time gap is 7 days. Okay, at least 7 days prior to the issue of circular, the deposit trust deed must be entered with the trustee in form DPT2 and a trustee must be appointed. Hope this is clear. Next, no person including a company that is in the business of providing trusteeship services shall be appointed as a trustee for depositors if the proposed trustee is, see, basically I have told you that there is a list of around 350 entities from whom you can select the trustee. Okay, now there are certain conditions for the selection of the trustee. Okay, what are those conditions? What he says is, no person including a company that is in the business of providing trusteeship services. Okay, basically providing trusteeship services is also a type of business. Okay, all the entities that are providing trusteeship services are separately listed. Okay, there is some around 350 plus names of list that is available where the entities are providing trusteeship services. Now this entity, okay, shall be appointed as a trustee for depositors if the proposed trustee is a director, key managerial personnel or any other officer or an employee of the company or of its holding subsidiary, associate company or a depositor of the company. Okay, generally if you want you can select from these 350 people. Okay, 350 entities, or you can also appoint some other individual persons also you can appoint. Okay, now if you are appointing any individual as a trustee, then such person should not be director of the company, key managerial personnel or any other officer or employee of the company or of its holding subsidiary, associate company or a depositor in the company. Hope this is clear. Okay, if you are appointing any individual as a trustee, then such individual must not be director of the company, must not be key managerial personnel of the company, or must not be officer of the company, or must not be employee of the company. Hope this is clear. Next, such person or such entity whom you are appointing as a trustee is not indebted to the company or its subsidiary or its holding or associate company or a subsidiary of such holding company. Okay, it should not be indebted to the company. Next, because see, basically in these cases trustee cannot act independently. Okay, if any of these case is if any of person falling in these cases is appointed as a trustee, then such a trustee cannot act independently. Okay, thereby there is a prohibition on appointing these type of persons as a trustee. Hope this is clear. Has a material pecuniary relationship with the company. Pecuniary relationship means relationship related to money. Okay, let's say he has taken some loan from the company. Okay, that means he is having some indebtedness with the company, or he has purchased some goods from the company on a credit basis. Okay, that means he will become debtor to the company, or let's say he has sold to the company some goods on a credit basis, that in that case he will be having he will become creditor. Okay, all these will be coming under pecuniary relationships. If at all the trustee is having pecuniary relationship, then you should not appoint such person as a trustee of your company. Okay, trustee for the deposit holders. Next, has entered into any guarantee arrangement in respect of principal debts secured by the deposits or the interest thereon. Okay, in case the trustee has given any guarantee on behalf of the company, even in that case you should not appoint such person as a trustee. Hope this is clear. Next, is related to any person specified in clause A above. Okay, if that person is relative of those persons specified in clause A, even those relatives cannot be appointed as trustee. Hope this is clear. Next, no trustee for depositors shall be removed from the office after the issue of circular or advertisement and before the expiry of his term except with the consent of all directors present at meeting of board of directors. Okay, if you want to remove the trustee before expiry of his term, then you will require unanimous resolution of the board of directors. Hope this is clear. Okay, consent of all directors, that means unanimous resolution is required to remove a trustee before expiry of his term. Okay, next, provided that in case the company is required to have independent directors, at least one independent director shall be present in such a meeting of board. Okay, if the company, there is a requirement on the company to appoint independent directors, means then at least one independent director must be present at the board meeting in which the decision to remove the trustee has been taken. Hope this is clear. Okay, and for which types of companies the appointment of independent director is mandatory, that we will be discussing in the directors chapter. Okay, there is a big provision related to this independent directors. Okay, section number 149 we will be discussing. Those were the provisions related to appointment of trustee. Now once you have appointed the trustee, trustee has to perform certain duties. What are the duties of the trustee? Okay, basically all these in these questions there will be no analysis. Okay, they are just like theory questions. You will be able to understand them if you just read them once. So what I'll do is, you just take some 2 minutes and read this rule number 8. After that we'll discuss. Okay, there are certain 8 points, okay, which will be the duties of trustees. You read those 8 points, then we'll discuss it. Okay, hope you read. Now, duties of trustees. What are the duties of trustees? It shall be duty of every trustee for depositors to ensure that assets of the company on which charge is created together with the amount of deposit insurance, you can strike this deposit insurance, are sufficient to cover the repayment of principal amount of secured deposits outstanding and interest accrued thereon. Okay, the first duty of trustee is to ensure that company has deposits, company has raised deposits. Now let's say deposits are some 100 crores plus interest 30 crores. On the other hand, company should create a charge on its asset, okay, for amount equal to that principal plus interest 130 crores. Now the trustee has to check whether the charge that has been created by the company on the assets is sufficient to meet that principal and interest or not. Okay, simply it has to check whether proper charge has been created or not. Okay, next, satisfy himself that the circular or advertisement inviting deposits does not contain any information which is inconsistent with the terms of deposit scheme or with the trust deed and is in compliance with the rules and provisions of the act. Okay, now the company will be issuing the circular. Now the points that are stated in this circular should not be against the provisions of Companies Act and should not also be against the terms and conditions that were specified in the trust deed. Hope this is clear. Okay, that has to be checked by the trustee. Next, ensure that company does not commit any breach of covenants and provisions of the trust deed. Okay, the trustee must ensure that all the terms and conditions that are prescribed in the trust deed are followed by the company. Okay, covenants means you can say as terms and conditions. Okay. Next, take such reasonable steps as may be necessary to procure a remedy for any breach of covenant of the trust deed or terms of invitation of deposits. Okay, in case the company breaches any of the terms and conditions of the trust deed, then what will be the consequence that has to be faced? Okay, even that has to be taken care by the trustee. Okay, take steps to call a meeting of holders of depositors as and when such meeting is required to be held. Okay, the trustee must also take care that the meeting of deposit holders will be held whenever it is necessary. Okay. Next, supervise the implementation of the conditions regarding creation of security for the deposits and the terms of deposit insurance. Again the same point. Okay, do such acts as are necessary in the event of security becomes enforceable. Okay, in case the company fails to repay the deposit, then the company has created security now. Okay, so the security can be enforced. Okay, in case there is any requirement to enforce the security, all the aspects related to enforcement of security has to be taken care by our trustee. Okay, on behalf of deposit holders. Okay, by selling that asset, by realizing the amount, trustee should repay the amount to the deposit holders. Okay, on behalf of company. Next, carry out such acts as are necessary for the protection of interest of depositors and to resolve their grievances. Okay, trustee should also take measures to protect interest of deposit holders and to resolve their grievances. Hope this is clear. Next, rule number 9, meeting of depositors. Okay, when should meeting of depositors be held? The trustee for depositors shall call a meeting of all depositors on requisition in writing signed by at least 1/10 of the depositors in value for the time being outstanding. Okay, let's say the total outstanding deposits are 100 crore. Okay, of this 100 crore, depositor holders holding at least 1/10, that means 10 crore. Okay, depositors holding 10 crores of deposits gives a or submits a request to the trustee asking to conduct the meeting of deposit holders. Okay, once such request is received, trustee must conduct a meeting of depositor holders. Okay. Next, the happening of any event which constituted default or which in the opinion of trustee for depositors affect the interest of depositors. Okay, any event that happens in the company, okay, and that event affects the interest of the depositor holders. Okay, even in that case, the trustee must conduct a meeting of depositor holders. Hope this is clear. That is rule number 9. Now moving to the next section, section number 74. Section number 74 related to repayment of deposits accepted before commencement of this act. Let us discuss that. Basically, the provisions of Companies Act 2013 were implemented in September 2013. Okay, at that time some of the provisions were implemented, not all the provisions were implemented, and on 1st April 2014 provisions related to acceptance of deposits were implemented. Okay, these provisions were implemented. Now, as per section number 74, all the companies which have accepted deposits before this date, okay, before commencement of these provisions, okay, before commencement of these provisions, Companies could have raised deposits now as per the previous act, all those deposits must be repaid within 1 year. Okay, within 1 year from the commencement of the act, or maturity period of these deposits. Maturity of period of these deposits. Okay, whichever is earlier. Okay, this is the provision of section number 74. All the companies which have raised deposits prior to commencement of this act, that means 1st April 2014. Okay, all those companies have to repay the deposits by 1 year from the date of commencement of this act, or by the maturity date of those deposits, whichever is earlier. Hope this is clear. Now by this you can conclude that maximum by 1 year. Okay, that means by 1st April 2015 all the deposits that were accepted under the earlier act must be repaid. Okay, this is the provision. Now the problem arises. If you see, let me draw the timeline. Now this is 1st April 2014. Okay, on this date commencement of act. Okay, the provisions related to deposits, okay, have come into existence on this date. Now from this date, within 1 year, that the deposit that have been raised prior to this commencement have to be repaid in 1 year. Now the problem is, what if, let's say, one particular company has raised deposits on some on some 15th March 2014. Okay, just 15 days back. Okay, just 15 days back. Okay, on 15th March 2014, one of the company raised deposits with a tenure of 3 years. Okay, now after 15 days, this new provisions has come, and as per the new provisions, the company has to repay the amount within 1 year. Okay, now all the companies, okay, which have raised the deposits went to NCLT. Okay, let's say if the companies have raised deposits in 2013-14, means by this time the maturity date would have been reached and they will repay. There is no problem with those types of companies. But what about companies which have raised deposits just few days back? Okay, they have raised deposits for 3 years. Okay, and after raising, they have invested the amount in the respective purpose for which the deposits have been raised. Okay, suddenly the act has come and they are asking to repay the deposits. Companies don't have the amount. Okay, once they raise the deposits, they will be raising it with particular purpose. Okay, and they will utilize for that purpose. And here there is another thing. Here company has raised for 3 years. Okay, and New Companies Act also says that you can raise the deposits for 3 years. Okay, there is no problem, you can raise the deposit for 3 years. Here company has raised deposits for 3 years only, but under old act, just because of the fact that the deposits have been raised under old act, tell me whether it would be fair to ask the company to repay the deposits. Okay, raising of these deposits is permitted under new act also. Okay, but because of the fact that they were accepted under the old act, okay, they are asking to repay those deposits under the new act within 1 year. Tell me whether it is fair. Okay, it is not fair. So when like this companies have approached NCLT, the time period has been extended. Okay, and there is another issue. If company fails to repay within 1 year, then penalties will be levied on the companies. Okay, obviously companies failed to repay in this 1 year, and heavy penalties were introduced on the companies also. Okay, so they approached NCLT, and there they have extended this 1 year period to 3 years. Okay, within 3 years, later on by an amendment, okay, in 2015 or so, by an amendment they have increased this 1 year period to 3 years. Okay, so all the penalties that were imposed on the companies are striken off, and the period has been increased to 3 years. But in the act you should read it as 1 year only. Okay, for the purpose of our syllabus, you have to read it as 1 year only. Hope this is clear. And also this provision is irrelevant now. Okay, because 3 years has already been completed in 2017. Okay, and there is no chance of asking this question in our examination. Okay, thereby section number 74 is irrelevant for our syllabus. Okay, but since they have given, we need to read it. Let us read. And another thing, they have extended this period of 3 years now. What if company is not able to repay even in this 3 years period? Okay, in that case company, okay, can approach NCLT asking to extend the period of time. Okay, even this option is available with the company to approach NCLT asking for extension of the time. Hope this is clear. If you want, you can make a note of this. Section number 74, example related to section number 74. These are old deposits. Old deposits. Okay, deposits under old act. You can pause and you can make a note. Okay, hope you are done. Yes, now let us read the section. I think here still, this one also you can make a note. The same example. Okay, yes. Section number 74, a very simple section and not so important. Repayment of deposits etc. accepted before the commencement of this act, where in respect of any deposit accepted by a company before the commencement of this act, the amount of such deposit or part thereof or any interest due thereon remains unpaid on such commencement or becomes due at any time thereafter, the company shall file within a period of 3 months from such commencement or from the date on which such payments are due, with the registrar a statement of all deposits accepted by company and sums remaining unpaid on such amount, with the interest payable thereon, along with the arrangements made for such repayment, notwithstanding anything contained in any other law for the time being in force, or under any terms and conditions subject to which the deposits was accepted, or any scheme framed under any act, and repay within 1 year from such a commencement or from the date on which such payments are due, whichever is earlier. Okay, they have to be repaid within 1 year and also within 3 months. Okay, act has commenced here now. Okay, on 1st April 2014 these provisions commenced now. Within 3 months, okay, company should file information with ROC regarding all the deposits that were accepted earlier and the amounts that has to be repaid from this. Okay, all these details of deposits which were accepted under the earlier act, okay, and still outstanding must be given to the ROC. Time period is 3 months. Next, the tribunal may, on an application made by the company, after considering the financial condition of the company, the amount of deposit or part thereof and interest payable thereon and such other matters, allow further time as considered reasonable to the company to repay the deposit. See, as we have discussed, if the company fails to repay the deposit, then it can approach NCLT asking for extension of the time. Okay, the NCLT, considering the financial position of the company, it can either grant extension of time or reject extension of time. Okay, next, if a company fails to repay the deposit or part thereof or any interest thereon within time limit specified in subsection 1 or such further time as may be allowed by the tribunal under subsection 2, the company shall, in addition to payment of amount of deposit or part thereof and interest due, be punishable with fine which shall not be less than 1 crore rupees. Okay, as I have already told you that earlier penalties were imposed on the companies. Okay, if you have accepted deposits under earlier act and you fail to repay the deposits within the period of 1 year, then a penalty of 1 crore will be imposed on you. Like this, a penalty was imposed, and then these companies have approached NCLT. Okay, then NCLT has extended the time from 1 year to 3 years. Okay, which may extend to 10 crore rupees, and every officer of the company who is in default shall be punishable with imprisonment which may extend to 7 years or with a fine which shall not be less than 25 lakhs, I guess 25 lakhs. Okay, these are the penalty provision that you have to remember. Next, register of deposits. Similar to that of register of shareholders, company needs to maintain register of deposits. Okay, in this register all the details related to deposit holders will be kept. Let us see what will be present in the register of depositors. See, first of all, name, address, PAN of the depositor. Okay, particulars of guardian in case of minor. Okay, in case depositor is a minor, then on his behalf the name of his guardian will be included in the register. Okay, next, particulars of nominee. If the depositor has appointed nominee, then the particulars of nominee. Deposit receipt number. Okay, once the deposits have been accepted, a deposit receipt will be given to the depositor. Even that deposit receipt number should also be entered in the register. Next, date and amount of each deposit. Okay, what is the date on which the deposit has been accepted and what is the amount of deposit. Duration of deposit and the date on which deposit is repayable. Okay, what is the maturity date of the deposit. Rate of interest at which the deposit is accepted. Due date for payment of interest. Okay, mandate and instructions for payment of interest and for non-deduction of tax at source. Okay, if the person is within the tax bracket limits, then you need not deduct TDS. Okay, regarding that you have to collect a declaration from that person. Okay, all those details should be mentioned in the register. Next, date or dates on which payment of interest shall be made. Details of deposit insurance. This one you can strike it off. Okay, because concept of deposit insurance is not present now. Next, particulars of security or charge created for repayment of deposits. Okay, in case deposits are security deposits, particulars of security that has been granted to this deposit, the same has to be mentioned, and any other relevant particulars. Okay, next, the entries specified in subrule 1 shall be made within 7 days from the date of issuance of receipt duly authenticated by the director or secretary of company or by any other officer authorized by board for this purpose. Okay, once the deposit has been raised, within 7 days you have to issue once the deposit receipt has been given to the deposit holder, within 7 days of issuing the deposit receipt, you should mention all the details in the deposit register. Hope this is clear. Next, the register referred in sub-rule 1 shall be preserved in good order for a period of not less than 8 years from the financial year in which latest entry is made in the register. Okay, from the last date on which the entry is made on the register, okay, from that last date to till 8 years you have to keep this register safely. Okay, the register has to be maintained by the company till 8 years from the last date on which entry has been made in the register. Okay, next, acceptance of deposits without compliance of the act, rules and notification could attract penalty and prosecution provisions. Okay, next, we're almost done, just left with 2 sections. After that we will be discussing the types of debentures. 2 small sections related to penalties. Okay, there will be nothing to be explained in that penalties. Section number 75, section number 76 here. See, damages for fraud. Basically this is related to section number 74. Generally under section number 74 you have to repay the amount of deposits that have been accepted before the commencement of the act. Okay, and the time period given is 1 year. Now if you fail to repay the deposits within a period of 1 year, then under section 74 only there is certain penalty that we have discussed. Okay, 1 crore rupees, that penalty we have discussed. Now if it is proved that the intention behind non-repayment of deposits is fraudulent in nature, okay, the directors have raised the deposits with an intention to defraud the deposit holders. Okay, in that case the penalty as per section number 75 will be imposed. Okay, apart from imposing penalty as per section number 74, the directors and the officers and the company will be liable for punishment under section 447. Basically it deals with penalty in case of fraud. Okay, that is discussed in this section number 75. Okay, you can go through that. Okay, this is just a penalty provision, there will be nothing to be explained in that. Next, section number 76A. Okay, if you contravene provisions of section number 73 or 76, then penalty as per 76A will be imposed. What is the penalty? The company shall, in addition to payment of amount of deposits or part thereof and interest due, be punishable with fine which shall not be less than 1 crore rupees or twice the amount of deposit, whichever is lower. Okay, this is a penalty on company. And on officer, every officer of the company who is in default shall be punishable with imprisonment which may extend to 7 years. Okay, officer of the company will be liable for imprisonment. Okay, if any contravention takes place under section 73 or 76. Okay, and fine which shall not be less than 25 lakh rupees but which may extend to 2 crore rupees. Okay, that penalty you have to remember. By this, entire provisions related to deposits have been completed. There is one pending point that needs to be discussed. Just a second. This one, this point. Basically what this point is, generally section number 73 deals with rising of deposits from members. If you want to raise deposits from members, there are certain 5 conditions need to be satisfied. Okay, issuing circular, registering circular, deposit repayment reserve. Okay, these 5 conditions needs to be satisfied. But in case of private companies, okay, rising deposits from members, they need not satisfy these conditions. Okay, let's say there is a private limited company, a wife and a husband, they have incorporated a private limited company and they want to raise deposits from members only. Okay, from themselves they want to raise the deposits. Now for this purpose, tell me whether it is necessary to issue circular. Okay, from for whom to the circular has to be issued? For the members only. Okay, there are only 2 members, wife and husband. They know how they are going to raise the deposits. Then what is the necessary for circular? Okay, and what is the necessary for DRR? So all that provisions, all that compliance is not necessary for private limited company. Let us see. Note, in case of a private company, clause A to E of section number 2 of subsection 2 of section 73 shall not apply to private companies. Okay, which accept from its members money is not exceeding 100% of the aggregate of paid up share capital and free reserves, and such company shall file the details of monies so accepted to the registrar in such manner as may be specified. Okay, as I have already told you that private companies can raise maximum up to 100% of the paid up share capital, free reserves and securities premium, and in case of startup companies they can raise even more than that 100%. Okay, but here for companies which are rising up to 100%, okay, for private companies which are rising up to 100% of paid up share capital, free reserves and securities premium, they need not comply with section number 73 subsection 2 clause A to F. Okay, that's it. By this provisions related to deposits are completed.